Welcome, everybody. This is a podcast for the Artists' Rights Institute. Today, we're revisiting with Tim Capel and Abby North about the Vetter v. Resnik litigation that Tim has been representing the plaintiff in and has resulted in a rather monumental decision in copyright land. So, Tim, why don't you introduce yourself and tell us a little bit about the case and how we got here. We've done a longer video that I'll link to, but let's have like a little brief recap of what it is and then what the status is right now.
Sure, yeah. Well, thanks, Chris, for having me on it. My name is Tim Capel. As you said, I'm a partner with the law firm Wells and Capel. I'm based out of New Orleans, and my law partner is based out of Chicago. We have attorneys scattered in various other places throughout the country. The Vetter v. Resnick case is something of a unicorn because what it called upon the court to declare was the geographical scope of both renewal rights under the 1909 Act and termination rights under the 1976 Act. And there has been no court that's ever been called upon to answer both of those questions. And so this case involved a song that was written in 1962 and was transferred away by my client, Cyril Vetter, and his co-writer in 1963 to a music publisher. And Mr. Vetter's co-writer died in 1972, which meant when his renewal copyright came due in 1994, his heirs took it free and clear from the prior claim, or the prior claim of the publisher. My client was alive in 1994 when the renewal copyright vested, and so his renewal copyright under the 1909 Act actually had to go back to the music publisher again for an additional duration of time. But he did have his termination right, which kicked in 2022. So we finally recovered his termination rights in 2022. And there was a licensing opportunity that came about after that had worldwide implications. It was a sync license that had the territory was worldwide. And the publisher, or the prior publisher of the song, refused to allow Mr. Vetter to license the work throughout the world and basically said, well, you can't issue a license for anything other than the United States. And so we sued to have the court declare the scope of the heirs renewal copyright, which my client had purchased a number of years earlier, and the geographical scope of his termination interest. And the court, after tons of briefing, very extensive briefing, the court determined that our argument was more persuasive, that there was nothing in the statute in the 1909 Act that would suggest that renewal rights were at all limited to the United States, and that these in regards to the termination interest, the language that Resnik and others point to in the 1976 Copyright Act about the geographical scope of these rights was better read to support our position, which is that when a author terminates a transfer, what they get back is all the rights under copyright that were previously transferred away. And what they do not get back is, they cannot void the contract in its entirety. So things like contractual rights, other sorts of warranties, reps, indemnification obligations, all of those stay exactly as they are. But if it is a part of the copyright that was transferred away, then you get back exactly what you gave. And so that's where the court issued an opinion on that. We wanted summary judgment. The defendant has now appealed. And so we're up on appeal at the Fifth Circuit. And the briefing schedule came out a couple of weeks ago. And so things are really starting to heat up.
Do you think one more time? I'm just thinking about some of the publishers I work with and the renewal versus termination. The part about the estate getting back under the renewal right or assignment. Could you
Yeah,
recap that?
sure. So you have to remember that prior to 1976, the 1976 Act, the duration of copyright protection was broken up into two terms. You had an initial term of protection, but then you also had the possibility of a second term of protection if you filed all the necessary paperwork, right? And that paperwork could only be filed by the author or the author's heirs. And that is because Congress, since at least as early as 1831, Congress had intended um, those renewal rights to be the author's second chance. And if the author wasn't alive, then it would be the author's heir's second chance to benefit from the copyright that was previously transferred away. And so that renewal interest went to Don Smith's heirs. The renewal interest also went to Cyril Vetter, but Cyril and Don had promised the original publisher that they would, once the renewal was vested, that they would transfer it back to the original publisher.
So there's sort
And
of a contractual assignment of the renewal right.
It's an assignment of the renewal right, which the Supreme Court held in a case called Fred Fisher, that was permissible. You could promise to assign your renewal interest. The only catch is you have to be alive when the renewal interest vests. And Cyril was, but Don wasn't. And so that's why the heirs took, in 1994, the heirs took the renewal right free and clear of the prior promise. But Cyril was stuck with his prior promise. And that's why his renewal interest went back to the publisher.
Right. Okay. I mean, to me, it's really kind of fascinating that there's the contractual assignment of the right, but then when you die, you don't have that right to assign.
Well, that's right. That's exactly right. So your heirs are not a party to that original contract, right? And so just like any there is what we would call in the law, like a stranger to the contract, right? And so any stranger to the contract, they're not in contractual privity. So the publisher can't hold that against them because there was no agreement between them. But there was an agreement between Cyril and the publisher. And so that is, that was valid. Now, what's interesting about that, Abby, is that in the 1976 Act, Congress expressly addressed this. And by saying in the Act that the termination right can be exercised notwithstanding any agreement to the contrary. Mm-hmm. So they knew exactly what they were doing. And that is they were trying to prevent the situation that the Fred Fisher decision allowed, mm-hmm. which was, sure, an author can promise to assign the renewal term. So in the 76 Act, they said, no, you cannot agree to assign your termination rights or your interest, or agree to waive your termination rights or anything like that. You cannot do it. So it's one of the few areas in which copyright law steps in to trump state contract law, and it's an interesting development mm-hmm. Throughout that process.
And this is all the more reason why it's sort of sort of consistent with the intent of Congress to protect the writer so that or author, I should say, so that the original author does actually recover the termination right without any side bets.
That's absolutely right. I mean, think about it this way.
All the copyright, right?
Right, all of it, right? And if you get back, if my opponents are correct, right, and the music publishing, the major music publisher, all these other people are correct, everyone who thinks that the district court's opinion is, off the rails, which mm-hmm. I don't believe it is, but there has been a lot of, talk around, frankly, some pretty rude talk about this judge and her capabilities. And I think it's uncalled for. I think people should go read the ruling.
Disrespectful.
But it is disrespectful. And, I think many of those people who are making those comments it's clear to me they have not read the order. Because if you read that order, you cannot walk away. You can walk away disagreeing, but I think I said before, you cannot walk away saying this judge doesn't know what she's doing, right? She understands these issues full well. I think she just disagrees with the other side, right? So I think if the opponent's position is correct and all that an author gets back is one sliver, right? There are 181 countries that are that have in the Berne Convention. So 181 countries, or 180 of those that respect United States copyrights throughout the world. And so if all a terminating author gets back or a renewing author gets back is one out of 181, countries, what sort of second chance is that? I mean, that makes no sense. If the prior publisher wanted to, you have to accept that if my opponents are correct, the prior publisher could purposefully block any worldwide exploitation of that work.
Yes.
100%. People say, oh, well, why would they do that?
And do.
It's in their financial interest to grant the license. Well, let me tell you something. When two people are not getting along, sometimes people don't operate within, the best business judgment. It is not as though people will always put aside their emotions or always put aside, extra financial considerations in order to pursue the dollar. That's anybody who's been a lawyer for any amount of time or done any sort of settlement can tell you that. And so if what you're saying is, well, yeah, we have that right to do it, but we would never exercise it. Well, I'm sorry, but that's not, you may not, but you can't speak for the other people. And so I just think that is a fundamentally inconsistent position with giving the author a second chance to say, well, you can have the second chance if I say so, or if, you just keep your exploitations within the United States. I mean,
It's
what
half a
sort of
second chance. You get half a second chance.
not? I mean, it's crazy.
So, one thing that this is making me think of, like, generally speaking, that the company to whom the right was assigned is usually a big publisher, right? Usually. And then the Cyril Vetters of the world are small publishers, right? But those big publishers will have 100, maybe 1,000 works that are kind of similar, same era, same genre. And if they chose to penalize that small publisher, they have so many other copyrights laying around for them to license however they want to. So really, it does disadvantage the small publisher, and particularly that author who has assigned, right, probably not knowing what they were doing when they made that assignment.
He was 19, and I can tell you for a fact that he did not understand what he was signing
Yeah.
at age 19. He was just a kid.
So I mean,
he
like, if
was a
you're
kid.
trying, yeah, sorry, it's like, if Congress's intent was to protect the author, then its intent was to protect the author. Like, I don't think you can protect this part, but not that part.
You're preaching to the choir on this one.
Yeah.
I mean, I agree, and I think that there's a compelling case to be made. There's certainly counter arguments that can be made, and I'm not here to denigrate those arguments. I think that there are some. This is an area where people can, reasonable minds can disagree, but I am confident in our position. I think that our position is the correct one. It is the one that protects the authors, which is whom the termination right and the persons who renewal and termination rights were created was to benefit the authors. And I think there's some quote like back in the 1800s that somebody was like, well, it's something to the effect of, as between the bookseller and the author, we choose the author, and that's in the congressional record, where it's expressed that this is not for the benefit of the publishers of the world, of the works, right? These assignees, whether it be labels, publishers, whomever, right? Renewal rights, termination rights have one beneficiary, and that's the author or the author's heirs, and that's it.
Yep. Well, there's, another quote that comes to mind is any given Sunday, someone's going to win and someone's going to lose. So, so here we are now. Now, have they noticed an appeal yet? Or
yeah, they've just been noticed. The briefing schedule's out. The record's complete. So
what is the briefing schedule?
Currently,
I mean, in a
The
nutshell.
Yeah, sure. So Resnick's appeal brief will be due, at least as of right now, on around April 23rd, so midweek of the week of the 21st. I will say that it is almost it is very common for a party to get a 30-day extension on this briefing schedule. So that I have not been asked anything around that, but I wouldn't be surprised if there's a 30-day extension. And then our brief will be due, around 30 or 40 days after that, whatever that is, whether the original date or or some sort of extended date. And then I think the important thing for your listeners and readers to understand is that if there's any interest in filing an amicus brief in support of Cyril and his position on appeal, those briefs would be due 7 days after, within 7 days. You can file them at any time, but the latest you can file them is 7 days after Cyril's brief is filed.
And that would be about what time?
Well, if everything goes as scheduled, then our brief will be due on May 22nd, and then that means the deadline for amicus would be May 29. So that's
Okay.
about 2 months from now. So if you're
Go ahead.
So I have two questions. The first one is, would you mind sort of explaining what an amicus brief is? And
Right, I
also,
was gonna ask.
do you have to be an attorney to file an amicus brief?
No, you don't. You have to be, well, I think most people have an attorney file. We can check, and we'll put in the show notes if there are any rules in the Fifth Circuit about amicus appearing pro se. I don't know anything off the top of my head that would prevent a pro se amicus, but what an amicus brief is it's called a friend of the court brief, right? And it's basically someone who has an interest in the outcome of the litigation, but it's not a party.
Yeah.
And so if you feel like you've got an interest, whether if you're an artist rights group or you're a songwriters group or what have you, or a literary authors group, if this matters to you, right, the outcome of this litigation matters to you significantly, and this could potentially reverse 50 years of industry practice. And so we should want this as a creative community. And if you are interested in this case, which you are, then you can file in support of either side, or you can just file and take no position on the outcome, but you can offer, if you have a particular area of expertise or something along those lines, you can offer an amicus brief for neither side, but just to help educate the court. And so I expect that there will be a number of amicus briefs on Resnick's side, because again, this is going to disrupt 50 years of industry practice. So my guess is that the industry is going to be weighing in on his side. I would love for them to weigh in on my side, but I'm not naive in that respect. And so the question is, who's going to be weighing in on our side, right? And I think that this is the time for this is like a shot, right? This has never come around before. And if the artist community, if the creative community wants to weigh in, this is it. Don't wait, right? Don't wait till it gets to the Supreme Court, because it may never get to the Supreme Court, right? They don't have to accept this case. I think regardless of the outcome, I think there will be a petition to the Supreme Court around this case, but they don't have to accept it. So this is your only chance to be sure that you can have your voice heard in court. And the way to do it
by May 29th.
Yep.
By May 29th has to be submitted. And how do you submit it? If you've never done it before.
Yeah, we can put in the show notes like a process to do it, but there's essentially you file a notice of appearance. You have to get both sides have to agree that you can file it, or you have to get leave of court to file it. Which is, when you get into some of these things, Abby, it's why it's usually helpful to have an attorney
Mhm.
to do it, because pro se litigants, it's not that they don't have something to say, that they don't need to funnel it through attorney, but there's some procedural stuff that that people who practice practice law are more adept to navigate.
Uh-huh.
If I could
And
just
so
add to that, I think it's important to say that this is different than, let's say, filing a comment with the Copyright Office. Or another federal agency where you can just kind of send an email and that's that. That's not what this is. And I agree with you, Tim, that it's probably better for people to be thinking about getting somebody to at least help them with the filing process. And very often, I don't know what the rules of the Fifth Circuit are, but I would imagine they're not that different than any other court of appeals. Very often they have some publication requirements and some printing requirements that have to be met, and those are not cheap. There are legal printers out there, so you can send something in, fairly rough form, shall we say? I mean, written proper, written to say they're not going to edit your content, but if you send it to them just sort of as you'd like it to read, they will go in and fix your formatting and your footnotes, and then put it in the form that the court wants it in, and print it if it requires actual printed copies. They will take care of all that. But of course, the more you ask them to do, the more expensive it is, and legal printers are not cheap. So I would
yeah,
say that it's probably I would budget, a couple grand, for that, if that is required. But the first thing I guess would be to find out exactly what the requirements of the Fifth Circuit
yeah, there
are.
are. I've filed amicus briefs in the Fifth Circuit in the past, and all of those printing requirements are there. And I
Right.
will tell you, if you're an individual and you feel like you have something to say here, what I would encourage you to do, rather than try and figure out how to file your own amicus brief, I would contact whatever. I'm sure you're a part of an organization of creative professionals in some regard, whether that is a group of songwriters, artists, what have you. I would encourage those organizations who have resources to file these things to kind of make their voice known, speak through that organization and really encourage them. I think that's probably the better way to go.
And
But
the
yeah,
and the
it's
lawyer,
critically important.
whoever's doing the filing has to be admitted to that court too. So,
Mm.
there's a few little, in this case, the Fifth Circuit. So that's a separate admission than, it's not like a bar admission, but it's a court admission. So
Mhm.
there is that hurdle to get through too. So if you're picking somebody, you want someone who's practiced at the Fifth Circuit,
Yeah,
And Fifth Circuit is
Texas, Louisiana, and who else?
Mississippi.
Mississippi. Yeah.
okay.
So it's look,
Although
it's
that
going
you
to
don't have
be
to live in those states
no,
to
no, no.
practice, but anyone who's active, as a appeals lawyer, would probably be admitted in multiple circuits.
Mhm.
Yeah, just to be clear, like one of the rules around amicus briefs, Abby, is that, I can't participate in it, right? Like it's not, I can't really be consulting with people who want to file amicus, because the court wants it to be sure that this is truly somebody else speaking
Sure.
and not me speaking through them, right?
Yes.
My speaking have to, and Cyril's, speaking have to come in our brief. So I think I would love for people to, if they want to learn more about this, they can contact me. But, and that my email address is tcappel@wellscappel.com. But in terms of like coordinating around amicus briefs, that's not something that I can do. But I'm more than happy to talk about the issues. I actually like talking about the issues. It gives me, a chance to sharpen the argument. So.
Yeah, I mean, I think it's actually well, so as a very, very independent, meaning one without the gigantic resources of the big publishers, as an independent publisher, like I have a few things going on. Number one, of course, I want to weigh in here because I have very deep thoughts. Number one. Number two, who's going to be the attorney? Like, I'm going to have to find an attorney, let's say, if I want to file a brief, I'm going to have to find that $2,000 for printing, right? So it seems like it might be that a bunch of independents should get together to be able to pool funds for these things, but also to be able to like hear you articulate your argument and do it. Now this is the second time we've done this. So either even I think there might have been some gaps for me the first time that now I feel like, okay, wait a minute, now I got this part that I might not have either heard or processed. So it is really helpful to hear you kind of say it over and over again, whether,
Yeah, no,
you know what I mean?
absolutely. And I'm happy to do it. And I mean, I want to be clear, like I think that a lot of industry folks have just looked at this as a, glass half empty kind of deal, or glass totally empty kind of proposition. But I think that it's far more mixed. And I may have mentioned it to, this to you all last time, but if we are successful, this is going to create a lot of opportunity for smaller publishers or big publishers, right? Because they will be able to go and negotiate and obtain, when they enter into a deal with a author who is terminated and reacquired their copyright, they will be able to go and negotiate with that author for the right to exploit the work throughout the world, as opposed to having to split it up into territories, which is what they've been doing. Now, I know the publishing industry is perfectly capable and comfortable with that split copyright syndrome, but you have to admit, it's a whole lot easier to get business done when you're dealing with a single publisher and somebody who has the rights throughout the world to grant.
Absolutely. And the other thing is that, it used to be conventional wisdom was like, okay, US is worth 50% and everything else is worth 50%. That I think has changed quite a bit. And I think that different publishers now have different perspectives about what each territory is worth. But further, it does matter. It makes a difference. The copyright itself, right? That audience, so it's not cut and dry. It is confusing when you are quoting for the world and you have some territories, but not all.
Right. And by the way, that 50-50 thing, like that's just plucked out of thin. Like there is nothing, there is absolutely nothing that other than sort of custom, which you mentioned is shifting and can shift,
Yeah.
that would dictate how much the author in the United States should get from a worldwide license versus how much the original publisher should get for the rest of the world. They could take the position, Abby, that they keep, like 1/181, right? Like they could just do it by
100%.
territory and say,
Absolutely.
okay, we do 181% of the fee, because that makes sense, right? And you would say, no, that doesn't make sense. But the point is that if they wanted to twist the screws, they
Right.
could.
Yeah.
And that's just not something that I think, when people talk about, oh, this is going to create chaos, I'm like, well, I don't know. That sounds like chaos to me, where there's no rules around what territory is worth what. And so when you're trying to quote all this, and again, I'm not saying it hasn't worked. It has worked, but it's only worked to the extent that people operate in good faith and goodwill, right? And that doesn't always happen. And I think that is, that has to be recognized, along with the fact that just because you've been doing it doesn't make it right. And I think that was a point that we made with the court that resonated, was, yes, we acknowledge that you've been doing this, but go back and look at the law. I think you got it wrong. I think you've developed industry custom and practice around a misunderstanding or misreading of the law. And so look, I know it's hard to rip a Band-Aid off, but sometimes you just have to do it, And so that's kind of where we're at.
Thank you.
Well, so we will put this out. We'll put your information about people who want to file that friend of the court amicus brief, if they do. And And I guess good luck.
Thank you, Chris. Thank you, Abby. I really
Yeah, happy
appreciate
to
you
help.
giving me the opportunity to spread the word about this.
Sure, my pleasure. And so you gave your email address. What's your website?
wellscapital.com.
wellscapital.com. And Abby, if people want to reach out to you, how do they find you?
It's Abby, ABBY, at northmusicgroup.com.
Great. And I'm Chris Castle. We're artistrightsinstitute.org, and my law firm is christiancastle.com. So thanks, everybody. Appreciate your help. And we'll see what happens. We'll be watching this space.
Very
Thanks, y'all.
Thank you, Tim. Thanks, Chris.
Bye-bye.